began 2 weeks ago to serialize the subject we titled The Real Cost of Criminal Justice. The first part, we looked at access to criminal justice at the basic level, which is the police. And we concluded that what is referred to as access is a miniature passageway strewn with all manner of obstacles. Obstacles which can only be overcome with money, thus making mockery of true access to justice. In the second part, we directed our focus on the courts in our bid to determine the real cost of justice in our land. Unfortunately, the courts are not much better than the police. Just like the police, impediments to a litigant's access to get justice at the courts are deliberately put by the officials until the litigant speaks the language they understand. That language is money. So the true cost of access to justice at the courts is enormous. The court, which is so often referred to as the temple of justice, has become desecrated, so much so that worshippers leave its once hallowed sanctuary worse off. As we conclude this topic today, we turn our attention to the prisons, or what is now referred to as correctional centers. These centers are charged with holding both awaiting or pretrial and convicted inmates as part of the criminal justice process. While the pretrial inmates are kept pending trial or fulfillment of bail process, the convicted inmates are kept to serve their jail terms or pending payment of fines or execution. What is unanimous, therefore, is that the prisons are an integral part of the criminal justice system and can also contribute through their actions or otherwise to the debate on access to justice. Questions around the conditions in which the inmates are kept pending trial, the timeliness and frequency of producing them in court for their dates, how their rights are upheld, amongst other questions, help us determine what cost we can put to the issue of access to justice at the prison level. A beneficiary of our legal aid program who stayed in prisons for about 16 years awaiting trial, name withheld, shared with us nerve-wracking stories of the conditions in which they stayed in the prison. He described the food, water, cell conditions, beddings, clinic, legal process of his case, and general welfare as nothing to write home about. His story has since been corroborated by several other beneficiaries who stayed for periods ranging from 1 month to 16 years. You can do well to visit our website, www.zarefat8.org, for these stories. It's an open secret that the warders, prison warders, feed off the inmates. A neighbor that received some form of legal advice from me before he was arrested and remanded in correctional custody shared the story of how prison officials refused to release him on bail when the court order was brought, unless his relations parted with money. The relations were delayed until they rallied to raise the sum. Some former inmates also confirmed the fact that many inmates paid money before they could be allowed to enter the vehicle that conveyed them to the court on adjourned dates. To be allowed to visit relations, in addition to writing applications, a visitor is required to part with some money before he is granted access. In the prisons, we see the failure of the legal and judicial system firsthand and what real access to justice costs. The law sees a pretrial inmate as an innocent person undergoing trial and awaiting conviction or discharge. All his rights are still intact, except the restriction to his freedom as a result of an order of a court. Despite this, prison officials don't accord them any right per se. In the same vein, convicted inmates still retain their rights, except freedom, because a court found them guilty. It's a crime for a warder, for example, to kill, abuse, or dehumanize a convict who is not on death row. It can even be argued that killing a death row inmate in a manner not prescribed by the courts is an offense. However, in reality, these inmates are not accorded any enabling to assist their access to justice. If anything, the prison authorities further aggravate their situations and shut them out. As we refer to in the second part of this topic, the judiciary has contributed in reducing the accused person's access to justice. And we witness this abnormality, especially in the case of inmates awaiting DPP's advice or filing of information. This group of inmates wait without end to know if they are going to face trial at the High Court for the charge which the police brought against them and for which the magistrates remanded them. The legal advice process takes time. Similarly, when the legal advice is out and directs that they be brought to the High Court, they wait till eternity for the trial to commence. The correctional centers, though more of a holding place, have also contributed in no small measure to impede unfettered access to justice. As we conclude, we call on the various players in the criminal justice chain to urgently commence the path of reforms if truly we intend to be ranked as a developed nation. Nelson Mandela said, quote, "No one can truly judge a nation until he has been inside its jails." End of quote. Follow us on all our social media handles as RFA3. Like, comment, and share. My name is Ben Abraham, and this is Criminal Justice Focus. Thank you.